And we begin with a case that we've been following out of Utah, Park City, Utah. It involves a husband and wife that were living a very nice life. This is Kouri and Eric Richins. He's very successful, has this great company, and you know, they fall in love and they're raising 3 children. Raising 3 kids. All right, posing for the goofy pictures, all of that, right? You're doing what you're supposed to be doing, but apparently, and this is according to prosecutors, she became obsessed and needed money. They had separate bank accounts. Things were a little strange along those lines, and she's now accused of slipping him lethal doses of fentanyl inside a Moscow mule. And she killed him, murdered him. Now, what happened next was, it took a while. The investigation continued. They didn't make any arrests. They didn't charge anyone with anything. But then she wrote a children's book called Are You With Me? She wrote this to help her children and other children grieve the loss of a parent. She went on talk shows to talk about all of this. And she's trying to make money from this book. Unreal. Then shortly after the book is out and she tries to do this little mini book tour, she's arrested and charged with the murder. Court TV legal correspondent Chanley Painter has more for us as she puts together the timeline of this case.
Kouri Richins, a mom of 3 and a children's book author, faces multiple charges for allegedly poisoning her husband, Eric Richins, inside this home in Utah in March 2022. So what did she tell police happened inside this home they once shared? According to court documents, 33-year-old Kouri Richins told police that on March 3rd, 2022, she and Eric, her husband of 9 years, were celebrating her closing on a house for her business as a real estate agent. It was around 9 p.m. when Kouri says she made Eric a Moscow mule and took it to him in their bedroom, and he began to drink it, but she didn't stay in the room with him. According to what Kouri told police, one of the couple's children was having a night terror, so she went to go sleep with him. But she told police she left her cell phone behind in the master bedroom plugged in next to her bed. Court documents reveal, however, that Kouri's phone was active during this time, indicating it was locked and unlocked multiple times, and there was movement recorded on the phone. The phone also shows that messages were sent and received between the time Kouri claimed she went to sleep with one of her children and the time she returned to the bedroom. These messages, however, were deleted. It wasn't until around 3 a.m. the next morning that Kouri says she returned back to the master bedroom inside this home and found her husband, 39-year-old Eric Richins, unresponsive and cold to the touch. She then called 911. First responders arrived about 3:31 a.m. and found Eric dead on the floor at the foot of his bed. Weeks later, autopsy results showed that Eric had approximately 5 times the lethal dosage of illicit fentanyl in his system. And based on the medical examiner's opinion, Eric died from ingesting this overdose orally. Prosecutors could seek the death penalty against Kouri for aggravated murder. She maintains her innocence. Reporting in Francis, Utah, Chanley Painter, Court TV.
Okay, now, explosive new allegations that, from my perspective, if these are true, really bad for Kouri Richins. I mean, to me, it's game over. To me, it's almost an admission, a confession to all of this. The Summit County Sheriff's deputies, take a look, searched the cell block where the defendant is housed, including the defendant's specific cell. That search revealed a 6-page handwritten letter that the defendant wrote to her mother, Lisa Darden, hidden inside a book in the defendant's cell. The letter instructs Lisa Darden, her mom, to induce the defendant's brother, Ronald Darden, who is Lisa Darden's son, to testify falsely in this matter. The letter claims that defense counsel wants to link Eric getting drugs and pills from Mexico to the fentanyl that caused his death. No such link exists. Therefore, the defendant concocts a false narrative for Ronald Darden to repeat, whereby, quote, Eric told Rennie that he got pain pills and fentanyl from Mexico from the workers at the ranch. To protect the integrity of the proceeding, it is imperative that the defendant have no contact with Lisa or Ronald. That is the defendant's mother, and the matter is pending. The defendant's conduct in drafting and hiding the letter establishes her intent to witness tamper. Her reliance on Lisa Darden and Ronald Darden suggests their predisposition to tampering. Now, let me read it to you. It's called a walk the dog letter. Here's the actual letter. She wants to link, and this is, she's writing this letter. She, I think, is referring to her defense attorney, wants to link Eric getting the drugs and pills from Mexico, so we need some kind of connection. Here's what I'm thinking, but you have to talk to Ronnie. He would probably have to testify to this, but it's super short, not a lot to it. Upon information and belief, just like they say, a year prior to Eric's death, Ronnie was over watching football one Sunday, and Eric and Ronnie were chatting about Eric's Mexico trips. Eric told Ronnie he gets pain pills and fentanyl from Mexico from the workers on the ranch, but not to tell me because I would get mad. Ronnie should have texts from Eric talking about getting high as well. I mean, is this, you know, I talk about this all the time, you know, when the defense has to come up with something, they always come up with something. Is this how they do it? Is this an inside peek into the world of defending an accused murderer? That we've got to come up with something? We've got to connect it. We've got to connect the drugs and pills from Mexico to Eric getting them. Wow. Sounds kind of incriminating to me. Sounds like the jury should get to read this letter as well. Let's bring in our think tank, see what they have to say about it. Joining us tonight in Englewood Cliffs, New Jersey, criminal defense attorney, former prosecutor Al Wunsch III. Also joining us in Stamford, Connecticut, criminal defense attorney Darnell Crossland. And in Philadelphia, Pennsylvania, family law attorney Jennifer Brandt. Welcome to you all. Great to see you. Al, if you don't mind, I'm going to start with Darnell. Darnell, is this insight into the world of criminal defense? Am I getting a peek at what we're not supposed to get a peek at? Whereas, like, the defense attorney says, if only we had a link, if we had some evidence that would connect him to buying this fentanyl down in Mexico, this would be great. And then all of a sudden, the defendant starts finding the evidence. Is this how it's done, Darnell? Please say it isn't so. Please say it isn't so. I know that. Oh, it is?
No, it's not so. It's not so.
Okay.
It's not so. It's not so. I was going to say this is the walk the dog defense that was created in the guilty defendant's mind. And one thing the defendant does not want to do is try to help the defense attorney by walking the dog. I mean, that's not going to work. And when they overhelp, they overhurt themselves. So what the prosecution is going to show is a consciousness of guilt. If she's trying to do this to secure some kind of an acquittal, that's a consciousness of guilt because obviously it's impermissible. What the lawyer does tell the client is, in order for the prosecution to successfully carry their burden, they have to meet X, Y, Z. Typically, you go to the pattern jury instructions and say, the judge is going to read at the end of this case these instructions, and we have to make sure the facts fit this law in order for you to be acquitted. And that's what you try to explain. You don't do that for the defendant now to go out and start tampering the witnesses
and the way I took this is that the defense attorney is explaining, you know, if we can connect that, right, then, you know, then this jury's clearly going to have some level of doubt, probably reasonable doubt, if we make this connection. And then Al, I mean, she's now trying to make that connection from behind bars.
Oh, sorry, is it my turn now?
Now it is. I wanted to hear I had to hear from Darnell first.
All right. Well, Ben, I don't think that what the defense counsel has done is a problem. Okay.
No, not defense counsel. I'm talking about the defendant writing this letter.
Well,
trying to get mom and brother to come up with something here.
you know, when you're speaking with your client, you tell them, listen, this is what we need to do. When they manufacture stuff, it always comes back to haunt them. And it will always explode in their face, like it has happened here. You have a situation now where the individual has penned a script, sort of like a book, that, you know, says exactly what the trial is going to do, right down to the, you know, comments about, we were sitting there watching football and he said, I go to Mexico and get fentanyl and other drugs, but don't tell the wife. So this is a scenario that is going to come back to haunt her. The only issue, though, is that they said they found it in a book. I mean, I heard that their defense counsel is arguing that it was in an envelope marked for her attorney, which may be an issue with regards to the fact that they were violating attorney-client privilege.
So they want it suppressed. So
Of course.
So let me tell you. Let me ask you this, real quick, Al. Can you write a letter to your family on the outside, but give it to your lawyer to deliver? That's I don't.
Yes,
think
you
can do that.
Well, I mean, you know, you get situations. It's not necessarily the best thing to do, but when you walk into that room and you're talking to them, you know, sometimes they have messages that they want and things along those lines. Now, if you are in a situation where you are perpetrating a fraud upon a tribunal, that may be a much different scenario than this is a birthday card from mom.
Yeah. Jennifer Brandt, what do you think of the? Look how big the letters "walk the dog" are.
Yeah, I thought she was talking about actually walking her dog. But Vinny, what's troubling here is, I mean, there are a couple things going on. As Al pointed out, I mean, if this was a letter that was intended to be for her attorneys, you know, how the court got it and, you know, how it came about, how it came out is troubling. However, if it was in an envelope for her attorneys, why would she be writing to her mother, especially with these types of instructions? So I don't think any attorney would want to read this and say, oh my goodness, look what my client is doing. I mean, I think that is a problem in itself. Clearly, I think this letter should be shown to the jury. I think it really is not good for her at all, and it doesn't help her situation. And you know, seeing her cry and tear up just seems more unrealistic and unbelievable at this point now, having seen all the planning that's going on sort of behind the scenes.
So Darnell, let's take the defense at their word that this was a letter that was intended to be given to her attorney, right? And it's in an envelope for her attorney. When her attorney gets that letter and opens it up, does she have any ethical obligation to not deliver it or go in camera with the judge, you know, outside the presence of the prosecutor to say, oh my goodness, my client is trying to get me to deliver this letter that is trying to get them to make up some testimony? I mean, that's a tricky spot for you guys.
Yeah.
That's why I'm a prosecutor.
I'm telling you, you live in fat off the land in the prosecutor's office, and we do all the work, but you get all the glory on the court TVs after your career's over.
That's right. That's right. But so is there some sort of ethical obligation? Are you put in a bad spot? Do you just destroy the letter? What do you do? Because
no, not at all. This doesn't even come close to that. There's cases where, you know, your client walks into your office. We've been to federal seminars. They bring cocaine, say, what do I do with this? And
no, this is someone who's incarcerated, though, right?
No, I'm saying by way of analogy, the cocaine in your desk scenario is a tough one. You can't, if you keep it, you're in possession of cocaine. If you tell them to flush it, you're flushing evidence. So that's tough. This is not tough at all. This is just her coming up with some walk the dog nonsense. And all you do is tell her, I can't suborn perjury. I can't support this. We can't go with this because it's not true. And if I call you to the stand or call anyone to the stand to talk about this untrue stuff, I'm suborning perjury, so we can't do it. But I have no ethical obligation to put my client in a worse position than they were in when they met me, so I don't have to show it to anybody.
You just got to give her a tongue lashing, right? And say, don't you do that again.
That's it.
Okay.
Well, you also have to advise her that she can't go on the stand with that story. Okay, she's not going to be able to go up and testify as to that, because if it is blatantly false, you cannot, do that type of a situation with regards to a tribunal. You put yourself in jeopardy with regards to your law license.
When you say
can't
tribunal, it
perjure.
sounds so much more important, Al.
I'm sorry?
I thought when you say tribunal, it sounds so much more important.